Hello friends, hope you all are fine. I welcome you in today's lecture where we are going to discuss about information technology. It is a very relevant topic for all of us because today information technology, which is also called IT, is an inseparable part of our lives. Even in this lecture, we are sharing information with the help of technology. We all do a lot of activities using our computers and mobiles, like talking to your friends, sending messages, banking, watching a movie, buying products, and most importantly, sometimes seeking help in emergency. The right use of this information technology can make our lives easier, faster, and more convenient. But like all other technologies, it also has a dark side. Some people misuse this technology to commit crimes and pose a threat to our society. That is why we need effective laws and systems to protect us against this dangerous use of technology. In this lecture, we are going to have a discussion on the Information Technology Act 2000. We will call it the IT Act, which is the primary law in our country that deals with cybercrimes and electronic commerce. Before starting the discussion, let me tell you about the 5 modules of this lecture. In Module 1, we will be dealing with the introduction and concept of the IT Act. Module 2 will tell us about the structure of the IT Act along with its amendments. Module 3 will highlight the objectives of IT Act. In Module 4, we will have a brief discussion of the important sections of this Act. With Module 5, we will conclude this lecture. Now let's start with the first module, that is, the introduction and concept of IT Act. When Internet was developed, no one had this idea that this revolutionary and useful technology could be used as a tool that could be misused for criminal activities and which required new laws for its control. With the increase of technology, even the traditional crimes like fraud, theft, forgery, defamation, etc. were being committed through Internet. And to deal with it, the only major criminal law we had in India was the Indian Penal Code, that is IPC, which was enacted long back in 1860, when no one even thought of such internet offences like hacking, cyber-stalking, etc. Thus, it is evident that the traditional criminal laws were never sufficient to deal with the emerging cyber offences. Now, if we talk about commercial transactions, it is clear that the traditional business or commercial laws in India like Indian Contract Act 1872, Negotiable Instrument Act 1881 and other property laws were also inadequate to give protection in case of problems relating to electronic commerce. Because when these laws were framed, there was no documents or contracts in electronic form. So, we urgently needed laws to deal with electronic commerce also. This problem of insufficient cyber laws was present in almost every country of the world, and they were trying to deal with cyberspace issues by enacting their own legislations. The result was that we had a number of contradicting and no uniform legislations all over the world. So, to meet out this need of a new, coherent and uniform set of rules, the United Nations Commission on International Trade Law, that is also called UNCITRAL, proposed a law which aimed to serve as a model to all the countries. Therefore, this commission adopted a model law in the year 1996, which is called the Model Law on E-Commerce, that is MLEC. The same model law was adopted by the General Assembly of United Nations by passing a resolution on 30th January 1997, and it became the foundation for information technology laws of various countries, including our own country, India. The preamble of IT Act itself mentions that Indian Information Technology Act 2000 is based on this United Nations Model Law on Electronic Commerce 1996. Various countries signatory to this model law either enacted new laws or amended their existing laws in tune with this MLEC 1996. India was a founding member of UNCITRAL and also a signatory to this model law, and hence India had to enact the IT Act 2000. under its international obligation. Then, UNCITRAL adopted one more model law, that is on electronic signature, known as MLES, in the year 2001 to keep pace with the changing technology. Accordingly, India also amended its IT Act through Information Technology Amendment Act 2008. That is how international law influenced the legal development in India relating to information technology, and we need to amend our laws from time to time. Now, let's discuss the historical background of the Information Technology Act, also known as ITA 2000 or the IT Act. Realizing the need for a law to facilitate e-commerce and give recognition to the electronic records in India, a draft was created by the Ministry of Commerce, Government of India as E-Commerce Act 1998. It was redrafted and introduced by the government as the Information Technology Bill 1999. This bill was finalized under the headship of then Minister of Information Technology, Mr. Pramod Mahajan. This bill was passed in the budget session of 2000 and signed by the President of India, Shri K. R. Narayanan, on 9th May 2000. It was assented and enacted on 9th of June 2000. It was notified and commenced on 17th of October 2000. That is how the primary law in India dealing with cybercrime and electronic commerce came into existence. Now, as I told you that the Act was amended in 2008 and some changes were also made in 2017, we will discuss the structure of the Act in the light of present legal position. Structure of IT Act with its amendments. The original Information Technology Act of 2000 contained 94 sections, divided in 13 chapters and 4 schedules. But with Information Technology Amendment Act of 2008, Section 91, 92, 93, 94 and Schedule 3 and 4 were omitted. This amendment of 2008 came into force in 2009. That is why you will find these amendments shown as 2009 in the footnotes of BEAR Act. One more important point to remember here is that Section 66A, which was introduced by the amendment of 2008, was struck down by the Supreme Court in a landmark order dated 24th March 2015 in the case of Shreya Singhal versus Union of India AIR 2015. In this case, the Apex Court declared that the Section 66A of IT Act is not only vague but arbitrary. It also invades the right to free speech protected under Article 19 of the Constitution of India. In the year 2017, number of other sections were omitted and some changes were made mainly in Chapter 10 of the Act by the much debated Finance Act of 2017. This Finance Act of 2017 merged Cyber Appellate Tribunal established under the IT Act with the Telecom Disputes Settlement and Appellate Tribunal established under the Telecom Regulatory Authority of India Act 1997. Since then, no amendments were made in IT Act till date. However, rules were made on time to time under the Act to further develop the cyber law. For example, the Information Technology Intermediaries Guideline Amendment Rules 2018. In regard to these rules, the judgment in the case of Tehseen S. Poonawalla versus Union of India of July 2018 is very relevant, in which the Supreme Court gave the government full freedom to curb dissemination of irresponsible and explosive messages on various social media platforms, which have a tendency to incite mob violence and lynching of any kind. So, after the preamble, the preliminary Chapter 1 is given. It only has 2 sections. Section 1, as usual, tells the short title, extent, commencement and the application of the Act. Section 2 provides definition of the terms used in the Act. Chapter 2 also has 2 sections, 3 and 3A, which deals with the authentication of electronic records, digital signatures, electronic signatures, etc. It provides for the technical procedure on which a subscriber can authenticate an electronic record and also require that the procedure should be reliable. Chapter 3, which is from section 4 to 10A, deals with electronic governance, which you can see in the preamble of the Act is an important objective of this Act. It provides for legal recognition of electronic records and electronic signatures. It also provides for legal validity of contracts framed through electronic means, for which the government may authorize any service provider. Chapter 4 has 3 sections from 11 to 13, which deals with attribution, acknowledgement, and dispatch of electronic records. This is an important chapter for the purpose of evidence because the IT Act does not provide as to what evidences are required in case of a cyberspace activity or cybercrime. This is actually the part of the Indian Evidence Act 1872, but IT Act will give us the idea as to what activities are legal to do in a cyberspace and what not. Chapter 5 again has 3 sections from 14 to 16, which provides that a secure electronic record is the one on which a security procedure prescribed by the central government is applied. Chapter 6 is from sections 17 to 34. It talks about the regulation of certifying authorities, which includes the controller, deputy controllers, assistant controllers and their functions, etc. It also provides for application for license, its requirements, validity, rejection and suspension. Chapter 7 of IT Act is from section 35 to 39. It provides for electronic signature certificate issued by the certifying authority. It clarifies what a certifying authority actually certifies in a digital signature certificate and how this certificate is suspended and revoked. Chapter 8 has 4 sections from section 40 to 42 because it includes section 40A. In this chapter, the duties of subscribers of generating the key pair and control of private key are provided. Chapter 9 is from section 43 to 47. It is an important chapter as it provides for penalties, compensation and adjudication. In this chapter, an adjudicating officer is appointed by central government who shall exercise jurisdiction only in this chapter to adjudicate matter in which the claim for injury or damage does not exceed rupees 5 crore, and if it exceeds rupees 5 crore, then the power is with the competent court. Adjudicating officer appointed here is deemed to be a civil court. So remember, he cannot exercise his jurisdiction in chapter 11 because they are offences and not civil matters. Chapter 10 under section 48 to 64, almost half of which are omitted, covers about the appellate tribunal, which is the Telecom Disputes Settlement and Appellate Tribunal. In this chapter, any person aggrieved by an order made by controller or an adjudicating officer may prefer an appeal to the appellate tribunal having jurisdiction in the matter, and if a person is aggrieved by any decision or order of the appellate tribunal, he may file an appeal to the High Court. Chapter 11 is related to offences. A long series of cyber offences and also the establishment of a national nodal agency have been provided from section 65 to 78 along with their punishments in this chapter. But still, the cyber crimes are increasing day by day. It is to be noted here that unlike chapter 9, the trial of offences committed under chapter 11 of the Information Technology Act would be held before the judicial magistrate under the provisions of Code of Criminal Procedure 1973 because they are criminal matters. Chapter 12 with only section 79 tells us in which cases the intermediaries shall be responsible. Chapter 12A again only with one section, that is section 79A, provides for the examiner of electronic evidence. Opinion of this expert examiner is very relevant for the purpose of evidence. Miscellaneous provisions are given under chapter 13 from section 80 to 94, some of which you remember being omitted by the Information Technology Amendment Act 2008. Section 81 of this chapter provides for the IT Act to have an overriding effect. So, whenever there is a confusion whether the IT Act will apply or the IPC or any other law, we should keep in mind that IT Act is a special law, and if an action or offence sufficiently comes within the IT Act, the provisions of IT Act will override any other law. The decision of the Supreme Court in Sharad Babu Digamurti versus Government NCT of Delhi 2017 and in the case of State of Delhi versus Sanjay, that is of 2014, clarified the overriding effect of the IT Act. But still, on 26 October 2018, Bombay High Court had to decide the same thing in the judgment of Gagan Harsh Sharma versus State of Maharashtra. So yes, this situation of double jeopardy is still a challenge for the courts to take care, which could only be dealt with proper training of officials and awareness of legal provisions. Now, let's talk about the schedules of the IT Act. The IT Act is embedded with two schedules. The first schedule deals with the documents or transactions to which IT Act shall not apply. 5 documents including a negotiable instrument other than a check, a power of attorney, a trust, a will, any contract for the sale or conveyance of immovable property, or any interest in such property are mentioned in the first schedule. Other than these documents, the central government has power to notify any other class of documents or transactions on which the Act shall not apply. The second schedule deals with electronic signature or electronic authentication technique and procedure in which, as per subsection 1 of section 3A, should be reliable. As I mentioned earlier, the third and fourth schedules are omitted. Now, module 3, which tells us the objective of the Act. The objectives of the Act is mentioned in preamble, and some of them are to encourage electronic commerce, facilitate electronic governance, amendment of the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891 and the Reserve Bank of India Act 1934 in reference to the IT Act, and to stop computer crimes and protect privacy of internet user. To fulfill the obligation of UN CITROL model laws. Module 4. Discussion of important sections of IT Act. Friends, besides some of definitions, mainly chapter 9 and 11 are important for our course. But first, let's know about the applicability of the IT Act. As per section 1, it applies to the whole of India, except on first schedule. Section 75 provides that person of other nationalities also come under this law if the crime involves a computer or network located in India. Section 2 of the IT Act provides for the 40 definitions. Although we cannot cover all of them here, I will explain digital signature and electronic signature. So, digital signature as defined in section 2(1)p means authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of section 3. This section 3 provides that any subscriber may authenticate an electronic record by affixing his digital signature. Digital signature is very secure, authentic and highly reliable and used as a means to secure document. Example of digital signature is email, contracts or a message sent via other cryptographic protocol. Now, let's know about electronic signature. It is defined under section 2(1)TA, which means authentication of any electronic record by a subscriber by means of the electronic technique is specified in the second schedule, and it includes digital signature. These signatures are used to verify a document. These are technically neutral, less authentic, and as compared to digital signature, vulnerable to tampering. Example of digital signature are attaching picture of your signature, name typed at the end of an email, a code or a fingerprint. Now let's discuss about various wrongs related to computers. They can be classified into two categories under the IT Act, that is, civil penalties given in chapter 9 and criminal offences under chapter 11. An aggrieved person can have remedies under both the chapters at the same time, as the nature of both the remedies is different. So, chapter 9 is from section 43 to 47, in which section 43 is important. It provides for the penalties and compensation for damages to computer system, etc. We should read section 43 along with section 66, because when the actions mentioned under section 43 are done dishonestly or fraudulently, they become an offence and are covered under section 66, which is an offence commonly known as hacking before 2008 and now titled computer related offences. Friends, you will find some more interesting information about the offence of hacking in part 2 of this lecture. So, section 43 covers under its clauses A to J the unauthorized access, unauthorized copying, downloading and extraction of files, introduction of viruses, damage to computer system and computer network, disruption of computer network, denying authorized person access to computer, providing assistance to any person to facilitate unauthorized access to a computer, charging the service availed by a person to an account of another person by tampering and manipulation of other computers, etc. I request you to please just go through the section from Bayer Act also, and you will find it in the language of the section. Section 43A, that was inserted in the year 2009, provides for the liability of a body corporate for protection of data. Section 44 and 45 provides for penalties in case of failure and contraventions. Under section 46, adjudicating officer is appointed who will exercise jurisdiction only under this chapter, and an appeal against his order shall lie to the appellate tribunal under chapter 10. Now, chapter 11, that is of offences. This chapter is from section 65 to section 78, in which long list of offences are provided up to section 74. However, the Act does not provide any definition of cybercrime. It can be invariably used for computer misuse or IT crimes, or it means a combination of crimes and computers. By not defining cybercrime and instead using the term computer related offences, the Act provides a scope to include any computer related activity which can offend us, thus giving the IT Act a broader scope to keep up with the emerging and new forms of cybercrimes. On the basis of their nature and purpose, the cybercrimes can be categorized mainly in 3 categories. Number 1, cybercrime against persons, for example, transmission of child pornography, harassment through computer, and cyber stalking, that means following the victim. Cybercrime against property is the second category, which includes, the example of which we can say, unauthorized computer trespassing and unauthorized possession of computerized information. The third category is cybercrime against government, for example, cyber terrorism. Bailable offences, as we know, are regarded as less grave and less serious, and in which bail is claimed as a matter of right. Non-bailable offences, on the other hand, are grave and serious offences, and in this, bail is not a right but a matter of discretion of the court. In cognizable offences, a police officer may arrest without warrant, whereas in non-cognizable offence, a police officer has no authority to arrest without warrant. Now I will tell you about the major offences in brief. For more discussion on these offences, please go through the second part of this lecture. Section 65 prescribes punishment for tampering with computer source documents. The object of this section is to protect intellectual property invested in the computer. It helps the companies to protect the source code of their programs even beyond copyright law. In the case of Syed Asufuddin and others versus the state of Andhra Pradesh, court held that tampering with source code invokes section 65 of the Information Technology Act. Section 66 is computer related offences, which actually dishonestly or fraudulently doing an act referred in section 43. In the case of R versus Whiteley, the accused gained unauthorized access to the joint academic network that is JANET, and intentionally deleted, added files and changed the password to deny access to the authorized users and hence invoked Section 66. Section 66A punishes sending offensive messages through communication services, etc. As already discussed, this section is declared unconstitutional by the Supreme Court in the case of Shreya Singhal versus Union of India. Section 66B provides punishment for dishonestly receiving stolen computer resources or communication devices. Section 411 of the IPC also has a similar provision to this section. Section 66C punishes identity theft, that is, fraudulently or dishonestly making use of electronic signature, password, or any other unique identification feature of any other person. Section 66D is cheating by personation by using computer resource. A person is said to be guilty of cheating by personation if such person cheats by presenting to be some other person. Section 66E punishes for violation of privacy, which is a serious issue in this era of rapid technological growth. Jawaharlal Nehru University MMS scandal was a shocking incident in this reference. Section 66F, that is cyber terrorism, is a threat to the unity, integrity, security and sovereignty of India, and it is punishable with imprisonment which can extend up to life imprisonment. Section 67 is about publishing or transmitting obscene material in electronic form. Its example is the case of State of Tamil Nadu versus Suhas Katti, which is about posting obscene, defamatory and annoying messages about a woman in the Yahoo message group by a man forcing her to marry him. Section 67A punishes the publishing or transmitting of material containing sexually explicit act, etc. in electronic form. Section 67B is the same offence by depicting children. The provisions of Section 292 and 294 of the IPC would also be applicable here. Section 67C, 68, 69, 69A, 69B and 70B punishes for failure to comply with the directions or failure to assist the concerned authorities given in those sections. Section 71, 72, 72A, 73 and 74 are mainly related to misrepresentation, confidentiality, disclosure of information and false publication. To conclude this module, I would like to say that the word cyber has overturned the human life. Today, we live more on cyber world rather than the real world. This makes the issue of privacy, security, integrity more relevant. Information technology knows no boundaries. Similarly, a cybercrime knows no barriers. The growth rate of cybercrimes poses many difficult challenges for legal fraternity all over the world. India is moving steadily on the path of cyber legislative development and made meaningful efforts with significant amendments in the Information Technology Act. New bills are also pending which will further strengthen the framework relating to cyber law in India. But still, so little is done and so much yet to do. With all this information here, we come to the end of part 1 of the lecture. To know more about cybercrimes and their practical aspect, I request you to go through the discussion in part 2 of this lecture. So, let's meet in part 2. Till then, keep using information technology, be alert and safe on internet. Wish you a cyber safe environment. Goodbye.